Hello, I'm Dominic Walker, JMW's Inside Man, and with Alison Parry. Alison is a partner at JMW's Manchester office and specialises in contentious probate. Hello, Alison.
Hi, Dominic. How are you?
I'm very well, thank you. And yourself?
Yeah, good, thank you.
So we wanted to talk today about George Michael's former partner making a claim in the estate, even though he wasn't part of the will, as we see from the newspaper reports, at least. So, I mean, how can a former partner of a deceased individual make a claim in the estate?
Yeah, so there are some ways in which they can. So there is an act, the Inheritance Act, which protects certain categories of people and helps them to bring a claim if they've been excluded from someone's will or if they've been left out by virtue of an intestacy. And in those circumstances, they can seek what's called reasonable financial provision from an estate. And a former partner might fall into one of those categories by virtue of being maintained by the deceased. So it's possible that George Michael's former partner was being maintained right up until his death by George, and that would give him the entitlement to bring a claim if he wanted to.
And you mentioned being maintained, so it's not necessarily that somebody's in the will that they can still make a claim.
No, not at all. They don't necessarily have to be in the will. I mean, some might say that you should be able to leave your estate to absolutely whoever you would want to. And 9 times out of 10, you would hope that's right, and people can go on and do that. But if someone's been maintained, then they might be able to bring a claim in the estate. And there are certain other categories of person as well who might be able to come into the mix and bring a claim. And one of the very common ones we come up against now is perhaps a child who somebody might want to exclude. And I think you and I would probably say if they want to exclude that person, for example, if there's been a long period of estrangement, then they should be entitled to. It's not always the case if that child is within a certain category and might be in particular financial need. In those circumstances, they can bring a claim.
And we are going off newspaper reports. So if somebody was to come to you with a similar situation to George Michael's former partner, what would you be advising?
Yeah, I mean, I think what we do is sort of initial fact-finding exercise, really. And we go, I mean, it's quite meaty, my job. We go into all the history of the relationship, which would obviously be interesting in a scenario like that. And we look at the way the finances were set up, the joint finances, both during the relationship and after the relationship. And that would give us sort of a really firm grounding on whether or not there was likely to be a claim that could be made. And then we also look at things like family dynamics and whether there's likely to be resistance on the other side to a claim. So in this particular estate, I think it's reported that it's worth about £100 million, the estate. And again, to you or I, that might seem like there's so much money there, plenty to go around to pay his former partner a small amount if he's been maintained by him. But you do often get sort of quite resistance on the other side. And I think some of the newspaper articles have said that George Michael's sisters and dad were quite reluctant to allow Kenny to have something out of the estate in this particular scenario. But that said, obviously a settlement has been achieved, as we've read in the newspapers, although the terms of that settlement have been confidential.
Alison, thank you very much for your insight.
Thanks very much.
And if you're in a similar position, obviously the numbers don't have to be the same in terms of figures. Do contact Alison via me, insideman@jmw.co.uk, or you can call me on 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.